Though I know the third party suffered injury and there's no formal claim, let me just keep quiet first lah until the claim actually comes in. Okay, so don't do that, because sometimes people will not want to report a claim because they're afraid that the insurer will increase the premium. Now, imagine a situation like the example I gave you earlier. You have forgotten to renew your policy and the claim actually comes in, then you are in trouble. You have to defend on your own. Okay. Next, do not admit liability without insurer's consent. This is in order to protect the interest of both parties. Because if you admit liability and say, yes, 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 I was wrong, it was my mistake. And although it may be your mistake, but you don't openly tell people, hey, yeah, it's my fault, I should have been more careful and things like that, because this will really make it very hard for the insurer to defend the case. Okay. Any material changes to the risk must be made known to the insurer. And of course, there's always subrogation. Subrogation means, example, GE will actually pay the claim if the insured is sued. But perhaps in this situation, the insured is actually not liable. Okay. So in that case, what GE will do, they will pay the claim and then they will try to recover whatever they have paid from the party that was at fault. Okay, so they will step into the insured's shoes and try to recover the amount by way of subrogation against the party that had committed the wrong. Okay. So far, okay? Okay. Okay. Some of the main exclusions on a product liability policy. These are very common exclusions that you see in the market. Okay. Injuries to employees. Now, injury to insured's own employees will not be covered because this would be covered under your WC or EL policies. Okay. And then product recall expenses. For example, remember some of the Honda cars had they recalled some of the cars to come in, they changed their airbags for them because the airbags were defective. Okay, so this kind of thing is a standard exclusion. Why? Because usually this is a standalone product or standalone policy, or you have something called recall expenses which can be extended on a product liability policy. So the standard product liability policy does not automatically cover product recall. Okay. Any warranties and guarantees, this will not be covered. This one, warranties, guarantees, you have to go. They usually have like a warranty insurance or something that the manufacturer provides. So this is not covered in the standard product liability policies. Now, damage to the product itself. Remember the example I gave you about the microwave that I bought and I brought home, it exploded. Now, the damage to repair, or rather the cost to repair the microwave is not claimable under the product liability policy. So damage to the product itself, not claimable. Latex allergy exclusion. This is a standard exclusion as well in product liability policies. This would affect those like rubber gloves, those latex products made out of latex, because some people are allergic to latex. So when you put in, say it's rubber gloves, you're a rubber glove manufacturer, and clearly rubber gloves, there's latex in rubber gloves manufacturing. So you can't impose this exclusion. If you impose this exclusion, then what are we covering? Because with this exclusion, if I'm allergic to latex and I use the gloves, then I'm going to have an allergic reaction. And if I sue the manufacturer and the manufacturer's policy has this exclusion, then the manufacturer is in trouble, because basically he has to defend the claim, okay, but the policy will not provide the cover. So these are things that you have to ensure, very clear about what sort of business your insured is doing. Yeah, involved in make sure that the cover that you're providing to him, if he's a rubber glove manufacturer, try to get the insurer to remove this exclusion. Okay, it's quite common, you know, a lot of insurers propose this. Of course, there are some that can also provide without this exclusion. So these are things that you got to look out for. Okay, failure to perform is not covered. Any financial loss, okay, also will not be covered. And any professional negligence, this also will not be covered under standard product liability. So in essence, I mean, you all know by now what does product liability cover? Covers third party bodily injury and property damage due to defect in the product. It does not extend to cover other type of claims. Okay. What are the defenses available? Now, sometimes when I'm a manufacturer, somebody sues me, then I realize that if the product is say defective, there's a loose wire coming out, but yet the customer bought it, went and plugged in, and of course got electrocuted because there's a what do you call it, a loose wire, you know. It's so apparent, that it's so obvious, you can see it. So the consumer actually knowingly used the defective product. In this kind of situation, sometimes the court may say, if the customer proceeds to sue, the court may say, oh, I will apportion liability equally between the manufacturer and the consumer, because consumer also knew that the product is defective but continue to use it. Okay, so the consumer will be held to be contributory negligent. Okay, misuse of the product. Sometimes the product is, you see the baby stroller in the picture, right? Yeah, got some chips on the front. They hang the jacket. Some people I see will hang umbrella on the stroller and then happily push the stroller. I mean, the whole purpose of the stroller is to put the toddler in and push the toddler. Sometimes you could have situations where you put too many things, heavy things on the stroller, and the whole thing can collapse also. Or it gets stuck somewhere and the whole thing can collapse. Okay, and then what happened to the baby inside will drop, okay, and probably get hurt. So any alteration or modification of the product, that means if you alter or modify a product and try to use it and you sustain injury, this will also not be covered, you know. And any criminal tampering, for example, if you say you're a manufacturer of a packet of chips, somebody, if they want to really be nasty, an independent person can actually open the packaging, put in some, I don't know, um, dead cockroach maybe, or snail or whatever it is, and close up the packet so that when consumer buys and eats it, wow, they see dead cockroach inside. So they will sue the manufacturer. This is criminal tampering. Okay. So what is the consequences when you have a product liability claim? As I highlighted, you can claim for damages, pain and suffering, loss of earnings, medical expenses, death, okay, legal costs and expenses, recall expenses. You have bad reputation for the product, so you have price erosion because now nobody wants to buy your product, no matter how much you give offer, reduce the price, nobody wants to buy it. So you also suffer damage to the market share, and you have unpredictable financial effects because of this. You also are unable to secure a market. That means your distributors no longer want to buy your product to sell because it is because of all the unfavorable bad publicity. Okay. Let's look at some examples. Latex gloves allergy claims, as I highlighted earlier. Okay, consumers can suffer skin allergy due to long or continuous exposure to the latex gloves. Okay, screw top claims. Some of these screw tops actually are defective, and contents of the water or other drinks and all that, there was a claim as a result, and the claim was paid for 762,000. Car manufacturers. Okay, there was a claim for defective painting, resulted in USD 1.5 million in Japan. Labeling, I've given you example about how if you don't label the packaging properly as to what it contents are and all that, your clients, customers can actually sue. Butter wrapper, okay, was contaminated as butter wrapper turns into green color, and claim was paid for USD 3.5 million. Okay. Defective chair, manufacturer of a chair. Somebody sat on it and it collapsed. Okay. And it causes spinal injury. Okay. They actually had to pay 285,000 for this claim. Any questions so far?
Hello, excuse me.
Yes.
Yeah, Miss Ariamala. I
Yes.
would like to check for the butter wrapper, for example, it turns green, but it doesn't affect or it didn't damage any bodily injury, right?
No,
Just
the
turn green.
thing turned green, and then of course, in order to be able to claim, if it just turns green, right?
Hmm.
If nobody consumed it and nothing happened, if you didn't suffer any injury, okay, then you can't claim.
All
Because
right.
ultimately, what does the policy pay for? Bodily injury, which includes illness and stuff like that. You
Yeah,
see, so you must
if nobody consumed that or even kena poison, or then cannot claim, right?
cannot claim.
But for the car paint, because the paint is damaged on the car, is it?
Yes,
Or
correct.
it's a
And if
property damage?
correct, you're right. Yes.
Okay, thank you.
Okay.
Hello,
Excuse
Mala.
me,
Yeah.
can I ask, during your presentation, talk about the occurrence claim and then product claim,
Yes.
we are catching the picture blur. Can you compare?
You want me to
What
explain
what is the
occurrence
difference
basis, is it?
compared to
Claims
occurrence
made.
basis claim and compared to product? What is the different
Okay.
the consequences? So that's
Okay. Okay, I get you. Let's go back a little bit to okay, this one. Claims made. Okay. Occurrence basis, I think you all are clear, right? Because your fire policy, your motor policy, your house owner, householder, all this will be occurrence basis, which is the normal type of policies whereby if I have sustained a claim, if I have a claim, say I'm involved in flood claim, okay? Say I had a flood claim last year in October. Okay, my policy is from January to December. I had a flood claim in October. I was unable to go to the get hold of the insurer and submit a claim. Okay, so I only managed to do that in January. My policy already expired in December, correct? Because my policy 12 months is January to December. I didn't even renew my policy in January because wow, my house got flooded, a lot of mess. You know, by the time I clear everything, lodge police report, and then go to my insurer to lodge a claim, it's already January. So in January, when I lodge a claim with my insurer, the insurer will lock it within I still had a valid policy when the incident happened, the flood incident. So the insurer will register the claim under the 2022 policy. Correct? Correct, you're with me, This is
yeah.
occurrence, Okay,
Right,
the
correct.
normal one, you're expert, more expert than me when it comes to occurrence-based policies. Now, compared to claims-made basis policy, in order to report a claim, first thing lah, in order to report a claim on a claims-made basis policy, you must have a valid policy to report when the claim happens. Okay, let's look at the same example. Okay, of course, this time the incident cannot be flat lah. Okay, say I bought a product in in October last year. I'm a retailer. I have a product liability policy effective from January to December last year. Okay, so consumer brought a product from me in October last year, October 2022. Now, consumer went home, same example lah, microwave example lah, okay? Consumer went home, explosion, and then consumer was, say, hospitalized, whatever lah, okay? So the customer actually appointed a lawyer, sent me a letter of demand, in November last year, okay? So, but I was careless lah, a retailer, I say, later lah, I report to insurer and I just left it. Then there's maybe got changes in my HR people, all that in the company. My policy lapsed in December. I omitted to renew my policy. Okay. So in February, say I received a writ of summons. All right. Now, remember, I don't have a valid policy in February. Okay. And I want to report this claim. If I report it to my insurer last year, my policy has expired. The insurer will tell me, hello, Mr. Retailer, sorry, your policy already lapsed. They will decline the claim because that is the essence of a claims made basis policy. You must have a valid policy to report a claim. And you cannot report, okay, let me give you another example. I hope you all can follow, okay, so far. Okay, let's look at the same example. Policy runs from January to December. Okay, in November, I have received a letter of demand. Okay, and I report it to GE. Okay, I send the letter of demand to GE Claims Department. Now, in December, same thing. I didn't renew my policy. My policy lapsed. Then in February this year, I received a writ of summons on the same policy, on the same claim. Okay. So now, although I don't have a valid policy, but I already reported this claim last year, right, under my previous policy. So I can still submit this writ of summons to GE and GE will have to look at the claim. Yeah, this is the difference. You must have a valid policy to report a claim. This is why with claims made, the liability policies as such, we tell you, everyone, that you must report claims. Don't try to, not report the claim. Even if, okay, I give you another scenario. I hope I've not confused you all, but another scenario is a situation where you renewed, same example, you renew the policy in January 2023 for 1 year. But you already received a letter of demand last year, okay, in October. You didn't inform GE. You go and appoint your own lawyer and you try to defend, okay. Now in February, when got rid of summons, then only you come to GE. So we will ask you, how come you didn't report last year? This is a claims made basis policy. You're already aware of this claim last year. So it's a bit tricky, when it comes to claims made basis policies. So you must highlight this to your insured if they have any liability policy. Okay, this is how the claims made basis policy works. I hope I have cleared your doubt.
Yes, this is very important.
Yes,
Mala,
yes.
yeah, can I ask you a question? In one of the
Sure.
previous slides, it was mentioned warranty and guarantees. Could you
Mhm.
explain to us the differences between warranties and guarantees?
Okay, basically, if you buy, say, for example, electrical products, right? It comes with a warranty, correct? Or a guarantee lah. So to sometimes it's just the terminology used, warranty, guarantee. Basically it means the same thing. Usually they will tell you, you want to extend or not, 2 years, 1 year warranty. The standard one is 1 year warranty. You want to extend, you have to pay more, pay extra. Remember when you buy your electrical products and all that, these are warranties, guarantees which will not be covered under a product liability policy. Why? Because the warranty or guarantee is given by the manufacturer. Okay, if you buy Panasonic product or Tefal or whatever product, Philips, is the manufacturer's guarantee, not the retailer or whatever, right? Because you can go to Aeon and buy a Philips product. Aeon does not give you the warranty. It is the manufacturer giving you the warranty. Aeon will buy probably a product liability policy, but it will not cover the product warranties and guarantees given by the manufacturer. Okay?
Thank you, Mala. So in other words, you're saying warranties and guarantees means the same.
It seems means the same thing. So it's just the term used lah, warranty, you know, if the product say I give you warranty for 1 year lah or 2 years, that kind of things. Similar kind of thing lah.
Thank you.
Hi, there's one question being said in the chat box. This AJ is asking, it's from Penang, Taima Risk Management. So is asking whether, we can arrange a liability policy based on occurrence basis.
Okay, this is general product liability on occurrence, is it? I believe she's asked, whoever the person is asking. Okay, usually for now, right, in the market, most product liability policies are on claims made basis. I don't think at the moment anyone does occurrence basis. It's all mainly on claims made basis, because all insurers, when you talk about products, I mean, if it's done on occurrence basis, they will not know the exposure, what sort of liability exposure they have. That is why they want to cap their exposures and losses. That is why they still maintain product liability on a claims made basis. Okay?
Hello, Mala.
Yeah.
I have one question here. Says a claim come from a cross-border claim. So when this incident happened, right? So which rules will apply here? Whether is the rules from the claimant's country or the insured country?
Okay. Usually on your policy, okay, there's two things. You will look at territorial and jurisdiction. These two words will always appear on your policy schedule. Okay. So maybe I'm a consumer. I bought a product. I came to Malaysia for holiday. I bought a product. Then I went back to my own country lah. Okay, overseas. Now, I didn't use the product or didn't whatever here. When I went back to my own country, I used the product and I suffered injury. So if you look at your schedule, most of the time it is common that your schedule will show territory. Maybe they will name certain other countries where you are distributing, where the manufacturer or retailer or supplier, where you're distributing your products. Could be Asian countries, could be Malaysia, Singapore only, or could be any country, China included. Okay, so as a manufacturer or a supplier, you would know where you are distributing your products. Okay, so you must extend the policy to include these territories. We call it territorial limits. Okay, so we will mention in the policy, maybe a territorial Malaysia, Singapore, Brunei, Indonesia. So we'll mention these 4 countries. Then the policy will mention this. When it comes to jurisdiction, usually it is Malaysia. That means jurisdiction is where you commence a claim. That means you commence, if you want to sue the manufacturer or the retailer or whoever, you have to do it in this country, not outside Malaysia. So very important, you have to look at the territorial jurisdiction. Okay?
Okay, thanks. Thanks.
Yeah. Okay.
Sorry, Miss Mala. Yeah, just in case the consumer, just now the example that you gave, the foreigner came to Malaysia and bought some products and went back to the country that doesn't spell out the territorial. Let's say we only spell out 4 countries, but actually this foreigner came from another country out of these 4 countries. So then they claim from there. So is it able to claim? I mean,
Yes, you're still able to claim because firstly, the person will have to bring an action in Malaysia and the person bought the product here. So you should be able to claim lah. I mean, the person so happens lives there, right? In the overseas country, but the person bought the product here, the manufacturer is local. The person brings the action in the court of Malaysia, I think they will still succeed.
oh, okay. So must bring back to Malaysia regardless of
Yes.
their territory
Yes.
lah. As long as
Yes.
we follow the jurisdiction, then
Yes.
it will be safe.
Yes.
Okay.
But of course, like if insured declares to us that they don't sell any products to USA, for example,
Mhm.
okay, then there's a consumer in the US, okay, who purchases the product there,
Yeah.
okay. Now, person gets injured or consumes the product and falls ill, brings an action in the Malaysian courts. Now, the question in this situation will be, how come your product is marketed to US? Clearly, in the proposal form, when you declare to us, when we underwrite the risk, we ask you, which are the countries that your products are distributed to? You never declare to us. Because don't forget, USA, Canada, the premium also is different. Okay, any exports to USA, Canada will entail higher premium. Okay, because of the legal landscape in those countries. Okay, so in this kind of a scenario, it may be questionable whether it's claimable under the policy because it's a material non-disclosure that insured is exporting products to USA, but they never declare to us. So it's
But
different, huh?
yeah, I know. Yeah. So
Yeah.
some in some cases, some of the insured, let's say they manufacture part of the parts in Malaysia, then they
Mm-hmm.
export to, let's say, Taiwan. Then
Mm-hmm.
Taiwan, okay, we spell out in, let's say, the territorial is Taiwan, but then the Taiwan manufacturer, they reassemble it and sell to US, which is beyond our
Oh,
knowledge.
this one, you see, you say they reassemble it.
Yeah.
So this one, that means there's some changes done to the product, right? Or
Yeah.
some, the product is probably put together with some other part product to manufacture the end product, maybe.
Yep.
Correct or not? So
Correct.
this will be the liability of the Taiwan manufacturer, I believe, will not be so much the Malaysian, the local manufacturer lah.
Okay.
So it
So
really depends, when a claim happens, we have to, at that point, we have to look at it closely.
yeah, so the US consumer, when they use it and got a product, bodily injury or what, so they take action against the Taiwan manufacturer. Then they found Taiwan manufacturer found that it is Malaysia's product that caused the
Error.
error. So
Okay.
they will come back and
Then what they will do is the Taiwan manufacturer who sued obviously will have to pay the claim lah. Okay.
okay, then
And
they
then remember the word
Malaysia,
subrogation, yeah,
subrogate
that I
Malaysia.
mentioned.
Okay,
Yeah.
yes.
Yes. So what the Taiwan manufacturer will do, pay the claim, and then if it is due to in the manufacturer in Malaysia, they will actually take out a subrogation action against the manufacturer in Malaysia.
Okay, thank you.
Yeah. Okay. Any other questions? Okay, If no other questions, then the final thing would be underwriting information required. We prefer if your client can complete a proposal form lah, because whatever questions that we want to know is already in the proposal form, because as you all are aware, you meet the client, you are aware of what the client is doing, what business they are doing, what products they are manufacturing or whatsoever. For us underwriters, we are in the office, we don't even come into contact with the client. The only thing that we base our pricing or our underwriting on is the minimum information that is provided on a proposal form. So that is why we always request, please get the insured to complete all the questions. Okay, if you're in doubt, you can always ask us. Okay, just ask. You don't understand, we don't understand this question. What are you asking actually? You can always ask us. Okay, then of course details of claims. Usually we will look at past claims in the last 5 years, and then most important is their product catalog or description. Okay, and if it is a new product which is not already being marketed in the currently, then we will also request for the relevant approvals from the authorities accordingly. Okay. These are some of the non-preferred risks. Animal feeds, fertilizers, these are all quite common lah, okay? Explosive, fireworks, flammable gases. Why? Because it's all very high risk, okay? Drugs, medicines, pharmaceutical products, medical equipment, ready-mix concrete, automobiles, watercraft, aircrafts, asbestos-related products, products exported to USA, Canada, products guarantee recall, product integrity impairment, tires, and also toys. Toys, because it is usually children who play with it. So sometimes there's always, if the parts are too small and if they are not labeled properly, the child can choke on it. Sometimes if you buy those cheaper toys, even the color can come off, and we know children like to put things in their mouth, those toddlers. So all these dyes can be poisonous, So toys are not our preferred risk. Okay. What are the challenges? We know as a non-motor agents, I know you all have a big challenge in selling liability products. It's not as easy as your motor and fire, because people usually will buy. It's very real that you have a fire claim, you're building on fire, you have to buy a fire policy. If not, you got no protection. Likewise, motor insurance also is compulsory. However, for liability, it's not compulsory. Okay, so of course, there's also not much awareness of the product. And as a result, there's really no push factor for the insured to buy. However, we always strongly believe that by way of more education, training, and also awareness, make the customer aware of such products being available, and also the importance of buying these products, then perhaps it's easier for you to market the products. Okay. So what you can do for yourselves is that you already have an existing customer base. I believe most of you have. So what you can do is you don't have to go and look for new customer. If your customer is a manufacturer, you go and see what does he manufacture. Okay, food distributor, wholesaler, what do they do? So you tap into your existing clientele, try to cross sell a product liability policy to them. So this is how you expand. Okay, try to cross sell, don't go and look for new customer. Okay, any questions? If not, we have come to the end of the product liability presentation. Okay.
Excuse me, for
Yes.
company director, we buy director liability. Then for accountant, we have accounting shop. You have to buy what?
Okay.
Professional liability or
Professional indemnity. Later on, the third session, the third
professional
after,
liability.
Will be professional indemnity
So that means
insurance for
the
accountants.
accountant can buy now.
Yes, accountants can buy. Yes.
Thank you.
Okay. You want to give them a 10 minutes break?
Yeah, thank you, Alamara, for a very good sessions. Yeah. Now, before we actually come to the second session, which is the CGL, I think let's pause for a short break, 5 minutes short break. Yeah. Thereafter we shall resume, and I know the agents may go for a toilet break, you may or maybe a cup of tea. Yeah, and then come back. Yeah. Stay in tune and don't lock out. Yeah, because if you lock out, yeah, then your attendance will not be actually recognized. Yeah, for these sessions. Thank you very much, everybody.
Thank you. Mala, can I ask you a question? Are you there? Mala, are you there?
Yes, I am. Yes. What's your question?
Thank you, Mala. I thought I
No,
was
I just mute the mic. So
okay. Now,
yes.
just you mentioned if we have questions or we are not sure of the answer to the questions or the terms and all, we can always ask you all.
Yes,
But
yes,
we
yes.
have access to you or not, or to any of the underwriters, Mala?
Okay. To answer this question, I think you would normally contact the business unit, right? I believe you all are from Penang, so it will be the branch, isn't it? Right.
Mm.
Am I right in
Yeah, but
assuming that?
things we would need to talk with the underwriter directly.
Okay.
At the moment, it looks like we have no access at all. We are
Really.
cut off.
Okay, let me put it this way.
Yeah, please.
Let me put it this way. Usually, I know like y'all will liaise with the Penang
Okay.
branch, right?
Yes.
Usually lah. Okay.
Mm.
So if you really need, I'm sorry, but it's not very convenient. Sometimes
I
you're
know.
not the only ones requesting, you know. So
Mm.
sometimes to have direct access to underwriter, a bit difficult. But what I can assure you is that if you really need to ask us something, technical questions,
Mm.
right? Or
Mm.
you need us to say you can't handle the client lah. Say we
Mm.
give you a quote, okay, and you can't handle the client because client asking you questions, you're not able to sort of explain to the client.
Mm.
Okay, we have
Yes.
situations like that. So in that case, you must tell your branch people, Penang people, whoever servicing you, be it Bipeng or Melvin or whoever it is that's servicing you, right? Tell
People.
them, look, I need help.
Yeah.
Can you arrange for the underwriter to explain the coverage to the client because client is interested. So no problem, we can come in to assist. Okay. If you don't understand, okay, when you do such a thing, right, the first thing we will ask you is, does the client have specific questions that they have to ask? Because sometimes we can just do it via email, not a problem. It's simple questions, sometimes very basic questions.
Mm.
Okay. Unless your client really has got complicated questions or really don't understand the cover at all. Normally first time buyer lah. Okay.
Okay.
So really don't understand. Then no problem. We can arrange for that. It's not a problem.
Right. Thank you very much, Mala. You
Yeah.
also deserve a break. You deserve more than any one of us. Thank you.
Hi everyone. We are back for the second session, which is comprehensive general liability. Okay. This one is as the heading, as the title, comprehensive general insurance. This is will be a bit boring lah, I would say. Okay. Because product, at least we can relate to something, right? CGL is very, very abstract. Okay. So you cannot relate it to anything in particular. Nevertheless, it's also a liability policy. And we will go through the coverage, extensions, exclusions, and claims examples. Now, CGL also protects your business from financial loss if you are liable for any bodily injury or property damage caused by your services or business operations. So if you own a small business, like for example, okay, now you would buy, say, a public liability policy, right? Say you got a small office business, you know, you run an office, or a small sundry shop, or you operate from home, for example, you sell cakes and whatnot. So you do have customers coming to your premise, to your home to buy. So you would actually buy a public liability policy. Now, this comprehensive general liability policy, first initially it started off as a public liability cover, okay, public liability premises policy covering business premises only. Okay, so if you run a business, you should consider buying a liability cover. Okay, especially if you have members of the public, clients, or customers that visit your premises. Okay, now, as I said earlier, originally it was a public liability policy. Then, how it developed into CGL is that one reason was because it's mainly due to contractual requirement imposed by those clients in the oil and gas sector. So if you're a contractor and you want to provide some maybe maintenance work or whatever it is, or if you're a telecommunications provider and you want to provide some maintenance work or whatever, you know, as a contractor, then the principal will require you to buy a comprehensive general liability policy. Okay. This is an example, Giant supermarket. Okay. This kind of say what are the exposures for Giant supermarket? Let's just look at an example. They will have to buy property insurances, their fire, con loss, plate glass, burglary, all this, right? Money and all that to cover the various exposures that the businesses might face. Then, of course, you have your employees, people working for you, right? That one will be covered if they have work-related injuries, then your WC and EL policies will cover that. And then, of course, you have the manpower like your PA, group term life, GHS, and all that for hospitalization and stuff like that. And finally, liability. Why? Because supermarket, hypermarket is a place, shopping center, malls, all these are places where it is always flooded with consumers, clients, third parties who visit the premises. Okay, so that's why if one of them comes in, I walk into Giant, the floor is slippery, and because they have just mopped the floor, I trip and fall. So I will end up suing Giant for whatever injuries I have suffered, and Giant will have to pay the claim if it's due to their negligence. So again, they will need to have a comprehensive general liability policy. If they don't, or at least a public liability policy, because if they don't, then when I sue them, they will still have to pay the claim, but they cannot seek any reimbursement from insurance. Okay. Let's look at the insuring clause or CGL. What it says is that the company, means insurer will indemnify, okay, the insured against all sums which the insured shall become legally liable. Don't worry, all those underlined in bold, I will actually go through shortly, okay, and explain what it means. All right, but these are the important points. Legally liable to pay in respect of accidental, two things, accidental bodily injury and accidental loss or damage to property. Okay, and this must happen during the period of insurance. Remember, during the period of insurance and in the course of business or operation of the business within the territorial limits. Clear? Let's look at it one by one. And the policy will also pay any costs and expenses of litigation. Okay. What's the meaning of indemnify? Indemnify means if I get injured, then the policy will pay me compensation, right? So compensation is to put me back to my original position that I was before I sustain the injury. So if, for example, if I walk into Giant, I trip and fall, I fracture my leg, and I have to use crutches, I have to be on crutches for 6 months. Okay. Now, I submit the claim to Giant. Giant will have to reimburse me medical expenses and also the pain and suffering that I have undergone, and until such times I'm normal again, like my normal self. Okay. So this is what it means by the word indemnify, to put back the insured to the same position before a loss happened. Okay. Legally liable. Okay. This one is based on the principle of negligence, whereby, as I explained to you all earlier, the insured must owe a duty of care to the customer. So if I'm a, same example, Giant Supermarket, if I'm an operator of Giant Supermarket, definitely anybody who comes to my premises to buy goods, I have to ensure that it's safe, right? So I must ensure when they mop the floor, they put proper signages up, all the cracked tiles, all these are replaced. You know, there's no loose tiles on the floor. Anything that drops and say there's a bottle of ketchup drops and breaks on the floor, it must be cleaned properly and quickly. Okay. So these are things whereby you have to do because you know you owe a duty. Okay. And then there must be a breach of that duty. That means there's a bottle of ketchup which has fallen on the floor and broken. I just leave it like that. Don't care. Okay. No SOP to say you must clean it up quickly, and properly so that customers who come in don't trip and fall. And then a customer walks in and trips and fall on it. So you have breached your duty of care. And as a result of that, what has happened? The customer sustains injury. So this itself will tell you you are legally liable to the customer. Okay. So this must exist. Okay, these elements. And then of course, damages. The person is injured or sustained damage to his or her property. Now, one is bodily injury. I could have also broken my watch that I wore because as a result of the fall, I could have, my watch got damaged. This is property damage also. So I can claim for this type of property damage as well. Now, generally, damages are of two types. You have special damages and general damages. Now, special damages are damages that can be quantified. For example, my watch got damaged, right? Cost of repair to the watch, okay? Medical expenses, loss of earnings. If I can't go to work for 2 months, 3 months, then the loss of earnings also I can claim because it's quantifiable. You can easily put a value to it, okay? Now, general damages, on the other hand, are damages that you are not able to quantify. It's more like pain and suffering, your injury, for example, okay? It's categorized under general damages. I can't walk for 6 months. So all these will be like physically impaired me for 6 months, So all these will be more under general damages. Damages that we can't really quantify in terms of dollars and cents. Okay. Accidental, of course, it must be accidental. Policy will not pay for any intentional act. Okay, so whenever there's something that has gone wrong, it must always be accidental. Okay, accidental bodily injury meaning whatever that has happened causes death, injury, illness to any person. Okay, due to their negligence, but it must arise out of the insured's business. Okay, loss or damage to property, I've already explained to you all, means actual or physical damage, okay, to third party property. Period of insurance, I'm sure you all know, okay, is the period of cover. In the course of business, so the act or error must have happened in connection or in the course of insured business or occupation activities carried out by the business, by the insured. Okay. Territorial limits means the location where the premise is, or business activities of the insured. Now, for CGL, it can be premise-based, but mostly for premise-based, like office risks and all that, usually it will be a public liability lah. Okay, because it's just a simple premise-based risk. But sometimes some people will take up a CGL, especially if you're, say, a aircon contractor, for example. If you go out to client's place to actually service the aircons, yeah, then the policy, you buy a CGL and it can be extended to cover when you go out to third-party premises to actually provide aircon services. Okay. Limit of indemnity, of course, is the limit. Not for CGL, right? It used to be on a claims made basis as well, just like products liability. But now most insurers are moving away from the claims made concept. You can buy CGL policies now. It's on mostly on occurrence base. Okay, and the limit is usually any one claim and unlimited, which means if you have a claim, for example, okay, let's look at the limit of indemnity. Say, example, limit, your policy says 1 million, any one claim, and unlimited, for example. So if you have a claim whereby the insurer has paid, what's the maximum the insurer will pay is 1 million for single claim. Okay, and your policy says unlimited. So during your period of insurance, you may have even 10 claims, okay, for 1 million each, and the policy will still pay because it's unlimited. But each claim is limited at 1 million. Clear? Okay. So this 1 million will comprise of compensation and the legal costs and expenses to defend the claim. Excess deductible, I'm sure you all know what this is. This is the amount to be borne by the insured first, okay, in the event of any claim. After exhaustion of the excess, then insurer will come in to pay the claim. Okay, costs and expenses of litigation. Now, legal costs and expenses incurred by insured due to a claim filed by the third party. This also will be covered with the policy. So, in a nutshell, we've looked at the insuring clause. In a nutshell, what we can say is that CGL covers exposures arising out of the business operation of the insured and mainly covers bodily injury, property damage, contractual liability, defense costs, and expenses. Okay, these are the main areas of cover for CGL. Okay. There are two forms of policies available, as I explained earlier, the occurrence form and claims made. But having said that, now for CGL, it's mainly written on occurrence basis. Okay, no more claims made. Very few insurers actually write it on a claims made basis. Okay, I won't explain again because I'm sure you all are clear on the explanation of the difference between occurrence and claims made. Any questions so far? Okay, if there's none,
Excuse me, for example, like a firefighting company, they have to go to factory to install all the piping.
yes.
Then if the piping in the factory fall down, spoil factory computer, for this,
Yes,
can claim or not? CGL can claim or not?
yes. Provided your CGL policy has been extended to include your work, that means you must mention to the underwriter that your business, your fire extinguisher manufacturer or whatever is contractor. So you go to clients' premises to actually fix the piping and all that. So yes, if you damage insured's property, then yes, sorry, not insured's property, client's property, then yes, there will be cover. Another example I can share with you is that, say, in an insurance company lah, we call the aircon service contractor to come and service the aircon, right? We are sitting down at our table doing our work. The aircon service contractor comes in, opens up the aircon vent to clean. Accidentally, one of his tools fall down and hit somebody in the office, one of the staff, and also damage the computer. Okay. Yes, these are claimable under their general liability policy. Okay.
Miss, one last question. In this case, we have CGL. That means we don't have to buy contractor always, because this one all claim is like everything claim. So contractor always no need.
CAR contractors all risk is different, because for CAR, usually you will buy CAR for construction risk. Usually CAR will be bought, right? The section 1.
But
CAR.
this one pasang pipe is also construction, construct the piping.
No. This one, okay, you see, if it is a construction risk, then you will have to buy a CAR. Usually they will spell out like if it's a construction risk, okay, that you will have to buy a CAR and a section 2 of the CAR to cover your third party liabilities. But in this case, you are a contractor, although you are doing the piping, but you are not like I mean, it's part of your work, when you install the fire extinguishing equipment or whatever it is, it's part of your job to do the piping, then a CGL would do, But if you're constructing, say, a new piping, whatever you need to go and install and all that, right? That one probably it's not maintenance anymore, isn't it? That would be a bit different lah. But usually, if it is you just go to do normal thing, say you install fire extinguishers in all the office you supply, okay, then you go to do checks whether they are working properly, all that CGL would do, no need to buy CAR. But if you're constructing anything new or something like that, I think usually they will ask you to buy a CAR. Okay.
Yeah, understand. You have more insight. Thanks.
Okay.
Hi, Mala, there's two questions being actually set in the chat box. Yeah, the first question from Anostar, she was asking, if a consumer fell down at shopping mall and injured, consumer must appoint a lawyer, then only sue the shopping mall management to bear for the medical costs.
Okay, good question actually, this one. Not necessary. You don't need to appoint lawyers. You can usually shopping malls, I think it's no surprise people having falls and all this. Usually the shopping malls, you don't need to appoint lawyer. You just write in yourself, okay? And usually I think they will oblige to take you to the clinic anyway and probably pay for you. So, I mean, I'm not sure whether they pay for you, but most of that time, I think it's like that, okay? Because it's quite common. So you don't have to appoint a lawyer. You can actually write in yourself and ask them for compensation. So all your medical bills, all this, you can actually claim reimbursement from them, and also for the injury that you have sustained.
Right, another question here also from the same agent. Yeah, what are the differences between public liability and comprehensive general liability? I think this is a very common question that normally agent will ask. Yeah. Right.
Yeah. Okay, usually public liability is usually bought for premise-based risk. Okay, like I said, highlighted earlier, for simple risk. Okay. CGL is for the it can be premise-based also. Like you can have comprehensive general liability. It can comprise of, for example, a public liability plus a products liability, like the giant supermarket. They also sell products. So it can be a combination, okay? Or it could be that you're providing, say, you're a contractor, so you need to go out to third-party premises to carry out your works. Okay, so it can be extended to cover when you need to go out to third parties' premises to carry out certain functions as well. Okay, that is in essence the main difference lah between public liability and CGL. Or CGL, you can also cover certain specific contracts. Sometimes you have principals requiring insureds to buy a CGL to cover specific jobs that they are required to do for a specific time duration. Okay.
Questions here asked by, oh, what about this financial liability? I suppose this is actually one of the process that in the comprehensive general.
Okay. Actually, I will be going through this in my next slide. So I will explain as I go along. Then if you still have doubts, maybe you can clarify lah. Okay. So let's move on first to some of the optional extensions available under the CGL policy. Okay. Now, one of the optional extensions available is comprehensive automobile liability.
Yeah. Over to you, Mala.
Okay, let's look at what are the optional extensions available as I highlighted just now. Comprehensive automobile liability for third-party property damage. Okay, now this one is an optional extension in a CGL policy. This is actually what it covers is that it covers third-party property damage over and above what is provided in the motor policies. That means for third party property damage, motor policy I think is limited to 3 million. So if you have a claim in excess of that, okay, then the CGL, this policy will cover it. Okay, but it's very rare lah. So far, we never come across a situation whereby there's a property damage claim that exceeds the limit provided in the motor policy. Okay.
Does this mean, Mala, does it mean it's a working risk?
Working risk. What do you mean by working risk?
Okay, for example, if they lift up using the mobile crane or the forklift
Mm-hmm.
to lift the thing or whatever material and accidentally damage to the party cars.
Mm-hmm.
Is it
But
fall under this scenario?
okay, in the first place, your crane depends. Some cranes can be considered to be on the road, right? They are licensed for road use as well. But some, those really huge cranes are only for within that designated work area, correct? That means
Mhm.
they cannot go on the road. You have to buy a different insurance to cover this, right?
Mhm.
Now, if you're talking about anything, say injury or property damage, whilst you are carrying out the work, okay, and you have the you have a CGL policy, I
Mhm.
think this type of damage will be excluded because you are actually working on the property.
Mhm.
Remember, your CGL is a third-party liability policy to cover property damage or bodily injury sustained by third parties. Okay, here you are working on the property, right?
I
So
mean, in short,
usually this kind of
it does not cover the principal property during this scenario.
yes, correct.
However, if they say there's a visitor come to the principal there, then you accidentally damage to the visitor car, then it's covered.
Of course, that is different lah. Yes, that's different. Or
Okay.
or the visitor sustains, say something drops,
Mm-hmm.
yeah, and the visitor sustains injury, then yes, it will be covered
Okay.
under the CGL.
Let me go back to just now. You're saying that this extension is actually limited to third party section for motor under the
Yes,
motor
for
coverage
over and above the limit provided in the motor
motor
policy,
policy.
which is 3 million.
Oh, okay. Okay.
There have not been situations lah whereby we have come across where it exceeds that limit. Usually
Yeah,
the 3 million is,
more
sufficient
than
for
enough lah.
whatever property damage. Yes, more than enough.
Okay.
Okay. Next is care, custody, control. This is actually a standard exclusion now. Okay. So any damage arising out of any property in care, custody, or control of the insured, okay, will not be covered usually. But we can give a small cashback, okay, for care, custody, control, an extension that means under the with the sub limit. Okay. Next one, somebody asked just now about contractual liability, right? Now, this is usually provided when you have a contract with the principal. Okay. Usually the principal gives you either you sign a contract and whatsoever, and then there are terms and conditions actually stipulated in the contract. It will actually spell out your scope of works, will spell out the timelines, okay, when you're supposed to do what and you're supposed to complete whatever job within a stipulated time and so forth. Okay, there could be many conditions like could state penalties that will be imposed also if you fail to complete the work within a certain duration and stuff like that. So one thing that you have to remember is that just because you have the contractual liability extension, okay, under the policy, it does not mean that the policy will cover every breach of contract. That means, say for example, there's a delay in the project. Okay, you can't complete it within the set time. Now your service agreement says, oh, if you don't finish the job within by March, end of March, then every additional week or every additional month, you're subject to a penalty. Okay, now this situation will not, this kind of penalty will not be covered, under the CGL policy. Okay, a lot of people are under the impression that when you have this extension, everything is covered. No, that's not so. Okay. Again, I go back to the feature of this cover. This is a liability policy and it covers you for what? Whatever act, error, or it indemnifies you for whatever negligent act in the course of your business operation. So that means whatever, if you're a contractor doing whatever it is, yes, if you have maybe caused injury to somebody or third party has suffered property damage, yes, that will be claimable under the policy. But not everything that's stipulated in a contract will be covered because that is different. You enter into a contract with a third party, with your principal, and if you breach it, it's breach of contract. Okay, it's not negligence. That's the difference. Okay, so remember that, not everything is covered. Okay. Now, damage to principal existing property. Now, this extension is also a standard exclusion, usually. And what it covers is that it is extended to include insured's legal liability, for any damage or destruction or loss of property by the principal, okay, as a result of performance of the contract. That means if a contractor is carrying out some works now, okay, some maybe maintenance work at the principal's premise, okay, and if the contractor actually is negligent, then yes, the policy will pay. However, if the damage is caused by the principal himself, okay, or principal had contributed to the loss or the damage, okay, this will not be covered under the policy. Okay, usually it is sublimited, right? There's a small sublimit usually given because it is a standard exclusion. Next, pollution is also a standard exclusion. However, we can extend the policy to include sudden and accidental pollution. Okay. There are certain conditions like that you must fulfill, okay, in order for the cover to, for the policy to trigger. Okay. The whatever pollution must be either an unexpected or unintended by the insured. It must take place during the policy period. And of course, it must have happened within 72 hours. That means it must be something sudden, like cannot be something that has existed for some time already. That means the insured already know, oh, I own maybe a petrol station, there's some petrol leakage somewhere. You know, he already knows it and he just leaves it for a while. Okay, that is not covered. Okay, so it must be sudden and accidental. Cross liability. Sometimes the insured named under the policy consists of more than one party. So if that's the case, if you have more than one insured, each of the parties, each of them are considered to be separate entities, separate insureds under the policy. So if there's a claim and one of them is negligent, okay, we will not actually subrogate the loss against the other party. So that means we will waive the rights of subrogation. Okay. Waiver of subrogation. Sometimes some of them, the principal will request for this clause lah. Okay, sometimes. Okay, so they will request for sometimes to add the name of another party into the policy as additional insured. So in those kind of situations, if there's a claim made against GE pays the claim, and subsequently GE will step into the insured's shoes and go after the third party that was negligent. Okay. So if it is found that the additional insured name in the policy has been negligent, and if you have this waiver of subrogation rights in the policy, then it prohibits GE from seeking recovery from the negligent party. Okay, it simply means that in simple terms. All right, waiver of subrogation. Let's look at some of the main. Yeah, there's any question?
Hi, Ma. There's one question from Penang again. Taima Risk Management. He was asking, can you share what is covered under contractual liability?
What is
Any
covered?
example? Yeah,
Example lah.
I think so. Yeah, he's asking.
Okay, you enter into a contract with you're a cleaning contractor lah, cleaner. Okay, window cleaner lah, simple example. And you enter into a contract with the principal to clean all the windows in this high-rise building. Okay. And then what happens? They require you to finish everything within a month. Okay. If say you, and then the
One US
contract,
cup is 8 US fluid ounces.
if you actually look into the contract, there will be other things stipulated like that if they don't finish the cleaning services within 1 month, then there's a penalty to be paid, for example. So in this kind of a scenario, say the guy is cleaning the windows on the gondola. Yeah, gondola. Okay, up and on the 10th floor. So while cleaning, the gadget he uses to clean the window actually drops. Okay, and injures one of the passerbys. Okay, or one of the office workers who are walking during lunchtime outside. They didn't realize the gondola on top. Okay, so this equipment drops and the person gets injured. Now, this kind of a scenario, it is stated in the contract that this is your scope of works. You are supposed to do cleaning services. It's stated. Okay, so anything in relation to the scope of services that you would ordinarily provide will be covered under the policy. However, your contract also states, okay, if you don't finish within 1 month, I impose a penalty. Okay, now, fines, penalties, these kind of things, it's not related. If you cannot finish within 1 month, it's got nothing to do with the service that you're providing. It's your own problem. Okay, so this scenario will not be covered. It's not something that the CGL policy will cover. Okay, I hope it's clearer. Huh? Yeah.
Taima, I hope Mana has answered your questions. There's another one that actually sent by Tan Yok Kwan from Ipoh branch. Yeah. So the questions goes in a way that the insured is a trading company involved in minor packaging. During the packaging process, some chemical mixing is involved and the chemical powder got blew out and stained the public car's park outside near the company building's walls. Currently, company bought public liability policy. Is this claimable? If not, what kind of extension can be included or liability can the company buy in future?
You're doing something in your manufacturer doing something like in your factory, and then all of a sudden something goes wrong and there's an explosion and it actually damages the car's park outside. Well, if the root cause is your whatever that you're doing in your premises, okay, your description is very brief, so my answer also will be based very briefly on what your explanation is. I wouldn't know what other independent intervening situations that could be. Okay, so in a straightforward situation like that, if the damage, the proximate cause of the damage to the car is caused by the whatever happened during the manufacturing process, then of course it will be covered now. Should be covered under public. Okay, because it's damage to third party property anyway. Okay.
Hello. Yeah. Aramara, can I ask something? Hello?
Yes. Yeah.
Yeah, okay. Actually, this is a customer actually is a trading company. Mainly is doing trading only. Predators is not a manufacturing company.
Okay. So
So
what happened actually? That means what caused this
actually, when he
damage?
bought the chemical, normally we do the buy and sell, but some of the client, they will require in a liquid form. So what they are doing is in the liquid form, when they are doing the mixture, just put in the water, of course, some other ingredients. So all the while is nothing happened these few years, but suddenly one day is a heavy rain and a strong wind, it blew out during the processing, it blew out this waste to somebody's car.
Okay.
So, mm,
What is the business occupation on the schedule? Policy
schedule is
schedule.
trading, is trading.
Exactly. So
Yeah,
it's
but
only
during
trading.
the,
You didn't
during,
include
yeah,
you don't include your, that means there is a process of some sort that they
a
carry
light
out on the
process, yeah, light
premises.
process,
Yes.
yes. Mm.
So it all depends whether the underwriter, when they underwrite this policy, they look at it as a pure trading risk, you are a trader only, or is there a process that you are doing? You see, it depends whether this has been declared to the underwriter or not when they underwrite the risk.
Because during the buying the time, so they are when they are explaining the time is mainly the business is in trading, it's not manufacturing. That's why
Exactly.
the rate will be calculated in the trading rate.
Yes. So if they decline the claim, it could be because of this reason that the insured did not declare that they're actually doing a process, they're not a pure trading company only. That's why earlier I mentioned, remember, please answer all the questions properly and disclose to the insurer, because if you don't disclose this right now, you're faced with a claim. As
No,
the underwriter don't know that you're doing the
no.
manufacturing
While doing
process.
this, when doing the process of buying this claim, actually we do exclude, we take picture and everything when we apply, for this insurance. So in the end, that's mentioned that because mainly the business is doing trading, not mainly is for the manufacturing. That's why in the end, they're calculated by the trading rate. So in other
So
words, never mind. I mean, in future, let's say he want to cover, what is the extension liability supposed to recommend?
I don't think there's any extension here. What you have to do is you have to, when you fill up your proposal form or when they underwrite the risk, you have to declare to them that, I'm sure there's the certain, if you're doing this regularly, right, then this would be their business already, isn't it? Part of the business, isn't it? You're not just solely a
A
trading
light
company.
packaging. What I mean is like not all the times yet they are doing, because some of the customer they just require in powder form. They mean they don't need to do anything. They just buy and sell only. But some when they request they want it in a liquid form. Maybe they add in some water and make it watery, and they will deliver the thing.
So in other words, what I can suggest from my viewpoint, there's no special clause to extend to cover this. But what you can do is, where in order to be able to cover this kind of situation, maybe there can be a memo or something included into the policy to describe activities of the insured, although they don't do it all the time. Okay. But because they do it anyway, so maybe you can request to include this process which they actually carry out into the policy by way of a memo. Yeah, there's no special clause to cover this kind of thing, because it's isolated things that they are doing, you see.
Yeah.
And an important thing, it must be there in their business description also.
Yeah,
If you just put as trading company, to me, I will underwrite it as a trading company.
Yes. Yeah. Right. Yeah. Yeah. Okay. Yeah. Thank you.
Okay. Yeah. Any other questions? If not, we move on.
No. That's it.
Okay.
Thank you.
So let's look at some of the exclusions. Okay, I run through very quickly because these are the main exclusions. Of course, there are more, but these are the main ones. Okay. Ownership, maintenance, operation, use, loading, unloading of automobiles, aircraft, okay, mobile equipment used in racing, speed, demolition or stunt events, activities, watercraft vessels operated by the insured, liability arising out of professional services, because professional services that is provided is covered under professional indemnity, which my colleague will be talking to you about shortly. Then product liability, guarantee, recall, of course, not covered because this is a CGL policy. Okay. Liability arising out of loss of pure financial nature, loss of goodwill, loss of market for your product, all this is not covered. Okay. Liability assumed under any contractual agreement like fines. Remember the contractual liability, you see, liability assumed, this is a standard exclusion, liability assumed by insured under any contract or agreement. So it's an exclusion, except unless it is something that forms part of your scope of services that you have to provide. Even if you don't sign a contract with the principal, but as a contractor, you're supposed to be providing that type, like window cleaning services. Okay. Then if your your negligent act is resulting from the window cleaning services, then the policy will cover. Okay. However, it will not cover everything that you contract for. Okay. Claims in relation to fines, penalties, punitive, aggravated, exemplary damages are all excluded. In general, I think basically most policies will not cover fines and penalties in Malaysia because it is against public policy. Okay. Bodily injury to insured employees and while in the course of employment will not be covered. Pollution also is a standard exclusion. And of course, waiver of subrogation. So who are what sort of business operation requires CGL cover? Supermarket, hypermarket, shopping mall, restaurant, hotel, industrial, your manufacturing factories, all these contractors performing installation, maintenance services, and of course the oil and gas maintenance contractors. Okay. So these are the category or examples of business operations that we frequently see requesting for a CGL policy. Okay. Let's look at some claims examples. Contractor installing aircon at client's premises. One of the tools falls and hits the client employee's head. So this will be claimable under the CGL policy. Property damage, as you can see, this guy is cleaning the window at the client's office. Accidentally, equipment drops on the client's glass table and breaks the table. Okay. So this is a property damage which is claimable under the policy. Restaurant owners, okay, an employee
Sorry,
mop the
Mala
floors.
disturb. So sorry a bit. Can you
Yeah.
go up to the previous slide again?
Sure.
Yeah, for this bodily injury, the contractor installing the air conditioner. So when it hits the client's employees, is it I'm not sure because some policy will state that it's a third party. So does the client's employees consider third party or yeah?
Who is the insured here? The
Uh,
contractor,
the
right?
insurer is a contractor, yes.
Correct. So insured's policy. Now, who is the one that got injured? Is is the client's employee, correct?
Correct. But if the client as a name, additional name insured, will that also covered under the employees?
No lah. Usually they won't request in that manner lah. Usually the contractor will just buy a policy. So when he visits the premises, any negligent act, okay, by him will actually be covered because the employees would be considered as the parties.
The employees are
Normally, we
considered third
don't
party.
find them to include window cleaning and all. They don't include the principal as third part as the insured under the policy.
Yeah, but
We don't see it.
some big corporations, they do request for their names to be included in the additional insured.
Yeah, you're right. Some
Okay,
MNC.
you can, I suppose, yeah, okay, the bigger corporations, maybe you can lah. In that kind of scenario, employee, I would still think that these people probably would be considered as third parties also.
So employees are considered third party even though we name the client as the additional insured.
Say you have a waiver of subrogation under the policy. So you cannot subrogate. If I sue the contractor as an insured, I think it should be covered under the policy.
So it will be covered, yeah?
It's a bit of a tricky situation, because
Yeah.
you have the insured also named in the policy.
Yeah, correct. So
And
sometimes
then-
we also confuse whether it's a
Correct.
third party, the employees
The-
are there considered third party. If we don't name them, then it's okay, right? Then it's
You
considered.
don't name them, then it's fine.
Okay, all right.
But mostly we don't see them
Or
being
if
named
there's
in the policy
cross
for this kind of
liability,
simple jobs lah.
Yeah, of course. But for big jobs, MNCs will request them to be included as
Yeah, suppose they will request them to be included as a name principal under the policy,
okay.
as additional insured rather.
Yeah. So if the contractor hit the employees, then just now you were saying it will be covered.
I think it should be covered because you still have to, the employee, there is a duty of care, right, to be provided.
Yeah.
Yeah, and you did breach the duty if you drop something on someone. So the only thing that sort of creates a doubt is the fact that you are an employee.
Mm.
This is the only thing to me, if at all, is a concern
Yep.
because you're an employee.
So we can say it's a definite answer or it's a gray area now?
It's a bit of a gray area, I would say, to be on the safe side, honestly. It's a bit of a gray area. Let me check on this. Let me
Sure,
check
sure.
with expert.
Thank you.
Yeah.
Thank you very much.
Yeah.
Yeah, bye.
Okay, let's go on then. Okay, an overhanging lamp in a boutique falls on the head of a shopping customer, thereby causing injury. This also is claimable. Plumber sent by a plumbing service provider makes a wrong move with high-powered tool, causing damage to customer's home, is also another scenario. Then you have a lot of delivery personnel nowadays, right? Delivering goods to you, installing, handyman working within client's office. If they cause any negligent act and injure someone or break any items in the office, this will be claimable as well. What are some of the decline risks that we will find? Oil companies are usually involved in drilling, exploration, refining, all this we don't do because it's very high risk. Terminal port operators liability, ocean marine liability, all this we don't do because it's quite high risk. Okay, shipbuilding, ship repairing, stevedoring, ship breaking yards, all this also we don't do. Any operation of railways, tramways, cable car, chair lifts, all this you can see all these are very high risk sort of liabilities which we don't want to do, basically not within our risk appetite. Okay. Owners, operators of stadiums, amusement parks, theme parks, operators of waste disposal sites, and then of course contractors engaged in wrecking or demolition of buildings. Okay, unless of course it is incidental. That means your main job function is not the demolition, but it is just incidental. Maybe 20% of it is incidental to your main job function. Then we can cover it. Okay. Construction of bridges, tunnels, all these dams, rock blasting, all these we prefer to stay away. What is the underwriting information required? I know now that for CGL, most of the time, insureds do not complete proposal form, but they tend to at least give us most of this information provided here. That means tell us who's the insured, limit, period of insurance, what's the scope of works, because we need to understand what's the business of the insured. Okay, location of the risk, estimated contract value or turnover, claims experience, And also, if it's a contractual requirement, then you usually will have an insurance article. Share that with us. And of course, if it is a project risk, then you will have a letter of award or a service agreement. Okay. So these are some of the minimum underwriting requirements that we require to underwrite the risk. Okay. Of course, it will be good if insured can actually fill up a proposal form lah. But if it is not possible, then of course give us information. Okay. Premium for CGL, how is premium computed? This one is really driven by various variables like the limit, the deductible. Some insurers prepared to cover, prepared to take on a higher deductible. Some of them prefer just a small deductible. Then, of course, your contract value, your period of cover sometimes could be multi-year. Risk exposure, this is very important, your scope of works. Claims experience, of course, is another factor. And the general market condition, okay, for this kind of industry or business. What is the going rate, okay? Okay, we have come to the end of comprehensive general liability. Any questions so far?
Excuse me, I have a question.
Yes.
Let's say during the contractor, they have a contractual agreement.
Mhm.
So they go to construct a factory, then they install, then the pipeline damage the factory property. This one, corporate general liability can claim or not?
Why your example very general? Oh.
The,
Because
the,
as I said,
the situation is you have a contractor
it's
agreement or letter of award during construction.
yes.
things
Okay,
spoil.
your insured, your agreement will also spell out the scope of works lah of the contractor, correct? What is the contractor supposed to do? Now,
Yes.
if it is something that he is working on and he damages it, chances are there's no cover under CGL because as I said lah, property work upon, okay, that's always a standard exclusion under the policy. So if he's working on that particular property or whatever, there's no cover unless he damages the property, which maybe accidentally something flew, go and hit the window or whatever lah, some independent thing like that, or injure somebody, then it's a different thing. Okay. But in general, any property that you're working on, if it's damaged, no cover. Because it's your own carelessness, and you're working on the property. Right? You're supposed to be working on this property.
Yes, I understand. But he also have another option that is to buy the contractor also.
Well, yeah, but you can also buy back lah. Usually, insurers are reluctant to provide a buyback for this. Usually, the property work upon. Usually, they will not provide usually property work upon. If
Okay.
it's a construction risk, then yes, you can take up a CAR with section 2.
Yeah, yes. Understand?
Because
Thanks.
because you mentioned it's a new factory, right? So
On the
yeah,
way,
if it is, yes, so you
work
have to
in
take up a
progress.
CAR,
The
which
work-
will cover the material damage. Because your section 1 covers material damage, right?
Yes.
Yeah.
Understand. Thank you.
Yeah.
Thank you.
Miss Mala, Casey Chong here again.
Yes.
Yeah, related to the what do you call it? Principal existing property, PEP. Yeah. So if let's say the principal is under the name insured, will this CGL also cover if we do not add the PEP? PEP is an extension, right?
No, exclusion.
Yeah, exclusion, but we can add on.
You mean principal's existing property?
Correct.
Is it?
PEP. Yeah, PEP.
That means you're talking about a scenario where the contractor actually damages the principal's property.
Correct, correct.
Is it?
Yes.
Okay. In this kind of scenario, right, if it is property that the contractor is working on,
Mm-hmm.
okay, and he damages the principal's property,
Yes.
there's no cover.
Okay.
Okay. Now, if it is a scenario where the principal himself damages the property, so be due to his sole negligence,
Yeah.
there's also no cover.
Yeah. Okay. But if the damage is caused by the contractor,
Okay, if damage, he say he's working on a certain part of the property lah. Okay,
yeah,
the
yeah.
contractor. But somehow he goes, say, taking a break lah. Okay,
Mm.
he goes for out for a while, away a bit away from the place he's working from,
Yeah.
for example.
Mm-hmm.
And over there, he takes his tools and everything, take out. He's a bit careless lah, didn't put everything properly into his bag.
Mm.
Okay, so while he's carrying and walking out, something drops out
Mm-hmm.
and say damages some equipment or something like a computer lah maybe.
Correct.
Okay,
Yeah.
this will be covered
Okay. So
because it is
yeah.
not the property that he's actually working on.
Yeah, so the work upon and PEP are two exclusions, right, under
Yes.
CGL. Yeah, so just now that one you were saying is work upon, but what about will it be excluded under the principal existing property as well? Because if for the example that you mentioned just now,
Which example?
the
What?
the tool that dropped on the device or the equipment,
No, that one will be covered because the
or that one will be
contractor
covered. Yeah.
put everything and then carry out the bag, go somewhere else, and then he drops something. Although still within the principal's premise,
Mm-hmm.
but it's not the property that he's actually working on.
Okay.
Okay. So if he damages, it will be considered damage to the party property, lah,
Okay.
which can be covered under the CGL.
Okay. Never mind. I just try to
Understand.
figure out again.
Okay.
All
Okay.
right. Sure.
Sure. It's a bit confusing, lah, actually.
Hi, just to add in, yeah. Can you hear? Okay, in CGL, basically we need to differentiate three things. Property will upon, principal property, principal existing property,
Existing property.
and number three, property under care and custody of the insured. Property will upon is a standard exclusion. PEP can be carved back. Your situation just now fall under principal existing property, PEP, and property under care, custody, and control of the insured. Also can be carved back, but very, very seldom, Mana?
Stems are very confusing. Okay, if there's no other question, any other questions? Okay, let's move on. I pass on to my colleague Azlina, okay, to take over for the next session, professional indemnity insurance. Yeah, Azlina, over to you. Yeah.
Okay, good morning. My name is Lina. So I'll take you through the professional indemnity insurance. We will have Q&A session, but please stop me if I go very fast or you have any questions along we go with the presentation. Yeah? Okay. So here's the control. Slides. Um, okay. First, please. Click that. Okay. So, okay. Here's the agenda. Okay. Okay. We will go through. Let's see what sort of cover available under the policy. And then, second thing, the extensions, the benefit that we have under the policy. Okay, but because at the end of the session, we hope that you will have a better understanding of professional indemnity. And most importantly, it can be a selling point for you to promote and sell the products. Okay, and number three is the exclusions. What are the things that are excluded under the policy? And then conditions that is to be complied by the insured. And then claims example. Tak protein nak. Okay. So, what are the professional indemnity? In layman, um, it is actually insurance that protect you and your business against claims for alleged negligence or breach of duty arising from act, error, omission in the performance of professional services. So basically, policy that's sold to specific professionals like engineers, lawyers, architects. It basically covers professional for claims made against them for breach of duty. Okay. So far, the professions that are required to carry their professional indemnity policies is doctors and lawyers. Yeah. Okay. Basically, to understand the policy better, and in order for insured to make a claims under the policy, there must be four elements. There must be a relation between the professionals or the insured and their clients. Professional insured relationship means that when their client appoint them for a professional service. And then there is a duty of care owed by the professionals. And there's a breach of duty of care. And number four, due to this, it causes a financial loss to the client or third party.
Lost the
Okay. Is there any questions so far? A professional, who are they? A person who has gone for a professional education or training, irrespective of particular professions. Okay, and their works is governed by an association. Means that they abide by regulations on irrespective of their duties and responsibilities. For example, engineers, they are governed by Board of Engineers, and architect by Board of Architects. Okay, these are example of professionals that covered under professional indemnity insurance. Here, professional under construction industries. I will read it out as you can see here. Okay. Now, okay. 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 I won't read this out because you can see here example of professions under construction industry. So in the next slides, we'll go through type of professional indemnity, which is two, and annual policy and also project basis. So these professions under construction industry, they can actually be covered under annual and also project-based policy. And these are the other professions or other professionals that can be covered under PI policy.
Oh, hi, Dina, there are some questions asked, a very basic one. Go back to it's from Ong Ling Tai, Penang branch, yeah. So it's a very general questions they ask, yeah. Public liabilities, fidelity liabilities, employer liabilities. Claim is under claim made basis, right?
Okay. Sorry, yeah, just repeat. Public liability, employer's liability, and
Fidelity liabilities.
fidelity guarantee FG lah.
So are they under this claim made basic?
No, that would be all occurrence-based policies. Mostly the claims made are liability policies, okay? With the exception of public liability and comprehensive general liability, which is written on occurrence basis. So, your question, to answer your question, no, they are all occurrence-based policies, okay?
For those claim has made in mid-year, the coverage still remains for the coverage.
Yes. You mean, come again, read out the question again.
Policy.
Alex, you're unmuted.
100K.
Yeah. So for those policies, yeah, which is 100 K, if claim has been made in middle year, the coverage still remain as 100K for the particular year.
You're talking about the non-liability policies, right? Or liability policies.
Or it's
for
a
sure.
continuation from just now, where
That
we
question, oh, the
conducted.
occurrence, okay,
Yes.
occurrence based.
Yes.
Okay, usually this will depends on the limit. Usually the limit is stated on your schedule. So if you have 100,000 limit on your policy for the whole year, then once you make a claim for that 100,000, you have two options. You have to either reinstate back your limit. So if you claim, it's say in February, last month you already claimed 100,000 from your policy, you have to reinstate. If not, you have a second claim policy already, once you exhaust your limit, policy automatically will lapse. You got no cover. Okay.
Okay, another question here will be from Tan Tian Chuan. At the moment, only doctors and lawyers are compulsory to buy professional indemnity insurance.
Yes. Only doctors and lawyers. Yes.
Yes, and then another question is from Taima. How about our agents' professional indemnity insurance? Is it on the claim made or occurrence basis?
Our life agents
Oh, yeah, it's on claims made as well.
claims made.
Mhm.
It's on claims made basis.
Claims made basis. Okay.
Other
Our liability life agent policy, okay, essentially it's a PI policy, so it's on claims made as well. Okay, next is the why professional indemnity insurance. So basically, this is the purpose of insured taking up PI cover, and this could be a selling point for you. I mean, to highlight to your potential client the importance of having a PI policy. Okay, in the first box, if a third party suffers a loss after relying on professional advice, they are entitled to recover their loss from the professionals. And second box, PI offers protection against errors or omission committed in the conduct of insured's profession. So basically, if I also could read out the insuring clause under the policy, that policy indemnify the insured for claims made for any claims or claims which may be made against the insured for number one, breach of professional duty in conducting their profession, and number two, to pay the costs and expenses. So these are basically cover available under policy, and if we could highlight to the client the importance of having a PI policy. Okay, as mentioned just now, this is basically a summary of policy cover. So, is indemnify the insured for any act errors or omissions due to a breach of professional duty, and number two, a legal costs and expenses. Legal costs and expenses is it is important part, important cover under the policy. And policy pays for financial compensation up to full policy limit as stated in the schedule. And the limit is available on aggregated basis. Have any questions? Lag ah, sekejap ya. Okay. These are the extensions available under the policy. The benefits basically available. It can be a standard exclusion under the policy, but can be carved back or can be buyback. Liable and slander, for example, is a useful clause in PI policy which offers coverage against defamation. All defamation cases filed against the insured. Okay, libel and slander basically includes those defamatory statements or materials which can have the negative impact on the reputation of a person in the eyes of the other. So, depending on case to case basis, we will provide a sub limit, or for some cases, it can be up to policy limit. And then number two, a loss of documents. Is basically provide cover for damage due to destruction or damage, loss or distortion of a third party or client's documents for which the insured is legally liable or responsible, provided that the destruction or damage or loss is due to unintentional or negligence of the insured. And then, so dishonesty of employees is a crucial component included in the policy because it compensates the insured for employees' action that may cause financial harm to the business operations. And then cover is also available for consultants and subcontractors or agents. This we frequently see under PI for project base. And the last one is the joint venture liability. Okay, because also available for frequently under project-based policy.
All right. Lina, there's one question from the chat box here. He was asking that for those public liabilities, of fidelity, employer liabilities to reinstate, if the claim not yet approved waiting adjuster report, can client reinstate the estimated loss amount or reinstate the amount after the claim approved?
Okay, sorry, I have to say this. We are liability underwriters, okay? We are not very familiar with the way the other policies operate, like fidelity guarantee and the other policy, okay?
Employees liability, is it?
Yeah, employers liability. Employers liability, can they reinstate? I don't think so. Can't reinstate for employers liability. So you have to buy whatever cover at the onset. Public liability also you cannot reinstate victim. So you have to buy the cover on what I mean is, okay, if you have a public liability policies or an employer's liability policies, okay, say you buy 500,000 limit, okay, at the onset of cover, you cannot go and reinstate midterm. Liability policies, all liability policies, okay, you cannot reinstate midway. Okay, compared to property insurance, I think you can reinstate. Okay, your windscreen, your motor car, like windscreen, you can reinstate. Okay, so it's different.
So Mala, the proposal is to increase limit, to do midterm increase limit.
I wouldn't say that. I would suggest your client would be the best judge. Your client, your insured, will be the best judge of what is the exposure they have. Because we can't assess, okay? We can give you options, but at the end of the day, what sort of exposure does the insured have based on his business, you know? So if you're running a business of a certain amount, then there will be a, of course you will take up if it's a small business, then maybe you take up a small limit, like 500,000. If you're running a quite a multi-million dollar business, then of course you don't buy a 500,000 limit policy. Like, if you have a claim, it will not be sufficient to pay. Okay.
We are clear, Alex? Okay. Policy coverage, limit of indemnity. Okay, basically limit of indemnity is available. Limit of indemnity is for 12 months policy period, is on aggregated basis. Remember just now when Mala was explaining about public liability, limit is unlimited. And comparing to PI, which is on aggregated, meaning that the limit will get exhausted once there's a claim. Okay, and then limit is actually available to pay for the claims, compensation, and also costs and expenses. This is based on insuring clause that I read out just now. Any questions? Okay. I don't think I will repeat a claims made based policy, or I need to. Okay. Okay. Professional indemnity is also on claims made basis policy. Comparing to occurrence basis. So I think after Mala's explanation, you are more clear about the difference between occurrence basis and claims made basis. Okay. Here, claims made is basically the explanation here, the summary here is that claims made against the insured and notified to the insured during the policy period. Okay, meaning that the claims must be notified during the current policy period, and at the time of insured notifying the claim, there must be an active policy in place. Okay. The difference between to be more clearer on difference of claims made basis and occurrence basis policy. Occurrence basis policy. Let's take an example of fire policy. Where, for example, the policy period is from January to December 2022, and in January 2023, when the policy is the 2022 policy is already lapsed, but it should notify the insurer on a windstorm incident that happened in December 2022. So what insurer will do is we will refer back to the 2022 policy that expired. Okay, but I mean, it will be subject to the terms and condition of the policy lah, including the claims notification, date notifications. Okay, but for claims made basis policy, unfortunately, this claim does not satisfy the claims made policy condition, where when insured notify the policy in January 2023, the policy is already lapsed. There's no active policy in place. Because two conditions must be satisfied is, number one, policy must be notified within the current policy period. There must be an active policy. And number two, the claim is something that insured is not aware of before the policy starts. Meaning that it's not an ongoing claims when the policy first starts. It's not a known claim to the insured. Okay. Here, example number one. Policy period is 1st January 2022 to 31st December 2022. Okay. Circumstances or claim made against the insured in December 2022. Insured report the claim to agent or insurer. And insurer will register this claim under 2022 policy. So means it satisfies the claims made policy condition. Because it is notified within the current policy period. Okay. And example number two is that claims made against the insured following to letter of demand in December 2022, and claim is not reported to agent or insurer. Policy lapsed and not renewed in January 2023. In February 2023, writ of summons filed against the insured, meaning that there is no cover because because the insured failed to notify the insurer or agent within the policy period, or at the time of day notifying the claim, there is no active policy in place. So we are clear about claims made.
What about Lina, Theo here? What about they renew with the same
And you may
insurance
notice
company?
that for every claims made policy, it will carry a retroactive date, comparing to occurrence basis policy.
Sorry, Lina, I think there's a question from Theo. Theo, do you mind to repeat your questions?
Okay, you're saying that the 2022 claim happened in that year. If let's say the policy is with us, and the next year, but the client insured received such a notification, maybe busy, overlooked, then the next year renew. Next year they renew with us again, and this because of the someone coming in, then they report to us. Would the insurance company or would us, will take up this claim? Let me in short, is the same renew. Renew with the same insurance company.
Sorry, Theo, the line's breaking up all the time. Do you mind to repeat the question so that Mala can just pick it up again?
Okay, can you hear me?
Yeah. Yes.
Can you hear me? Okay.
Yes. Yes.
What I want to highlight is that for discussion, let's say if the insured overlooked to inform insurance company that last year there's a claim, but when it comes to renewal, they also renew the policy with the insurance company, same insurance company. Is it? Can we? I mean, would the claim department pick up this claim?
Two things here, Mr. Teo, is it? You say that the claim was actually last year, okay, but insured failed, overlooked lah, to notify the
Ah.
claim,
Yes.
and he reported the claim this year. The policy is still renewed with the same insurer,
Yeah.
correct?
Yes.
In this kind of a scenario, of course, we will, when you report first, we will ask you, it's a formality. Why didn't you report the claim last year? We will ask you. Okay? If of course, if your reason is reasonable, then yes, the claim will be admitted under the current, say lah, you got personnel who has left the company, so nobody really attend to it, or some valid reason like that. Because you continuously insured with the same company, and we also, your policy will also carry a continuous cover clause. So by virtue of all of these, we will still entertain the claim. Okay?
Mm-hmm.
Yeah.
Okay.
Now, of
So
course,
in short,
that doesn't mean that you
in short,
wait for 1 year, after that only notify a claim that you're aware of lah. That is a bit unreasonable, because the important thing here is you cannot prejudice the insurer's stand.
definitely. Yes, understand.
Yeah.
Mm.
Okay.
Thank you.
Okay.
Sorry, Mala. Further to the question just now asked by Mr. Teo, if the insured insure with another insurer,
Mm-hmm.
under this kind of situation, will
Mhm.
the new insurer pick up the policy, pick up the claim, or
Okay.
both insurers will can wash their hand?
Both insurers, to be cruel, both insurers will wash their hands. Your previous insurer will tell you, Mr. Client, you didn't buy a policy with me, so it's a claims made basis policy. Your policy has lapsed, there's no cover. Now, your new insurer unfortunately will tell you, Mr. Client, you're already aware of this claim last year, and rightfully, you should have reported this to your previous insurer. It's a known claim. Claims made basis policy, you cannot report any claim that is already known or existed previously. Okay, very important. Whatever you're aware of, or if it's an actual claim, you cannot report it. It's an exclusion, standard exclusion. Any prior pending claims. Okay, it's a standard exclusion under the policy.
Okay, thank you.
Okay.
Okay, we can continue, yeah. Okay, here's the comparison between two main types of PI policies. As we mentioned just now, in the previous slides, there are two types, which is number one on annual and number two on specific project. Okay, annual PI policy basically covers the insured for all activities undertaken within the 12 months period, within the policy period. So it will be a 12 months policy, and it is written on annual basis, yes. And one large single project can exhaust the policy annual limit. Okay? This may not meet the contractual requirement due to a longer period required or certain limit required. Okay, we could see that the purpose of insured taking up annual PI cover is because of their awareness, the importance of having PI policy, and it could be a requirement imposed by authority or regulator for them in renewing their license. And number two, for specific project or single project professional indemnity. Okay, basically, policy will only cover the specific project, and it is a contract requirement imposed by the principal to the insured. Okay, and policy period are tailored to the contractual requirement. It can be multi-year, depending on the duration of the project. Okay, and it will be arranged on a separate policy between one project to another, so it will protect the policy from exhausted. And limit is also based on the contractual requirement. So we will have a different set of assessment between annual PI and a specific project. We will look at few important factors in charging the premium and also imposing the terms. Okay. Next, it's what limit to buy. We know as agents, you will face these questions raised by your clients or potential clients. We as insurers will not be in the best position to advise you the limit to be taken up, especially for annual policy. Comparing to project risk policy, where you will have a contractual requirement on what limit to be taken up, where it is imposed by the principal to the insured. But for annual policy, we don't normally advise insured what limit to be taken up, because we believe that insured will know their exposures well. And what we will do is that we will suggest a few options of limit. And the best we can do also, we will advise you a limit taken up by other insureds in the same industry. Meaning that we'll provide the insured or the client a benchmark of limit taken up by client in similar industry, maybe in similar size of fees, similar size of firm. Okay. And we will share tips in deciding what limit to be taken up, depending on the risk exposures, client's budget, their operations, and then size of their firms, and then type of the activities carried out within a year, and also requirement imposed by the principal. Okay. These are informations that we require in assessing the risk and provide you with quotations. Completed proposal form, or at least the last year proposal form from other insurer maybe, so that it will give us an idea of the risk. We know agent will always require our reply on urgent basis, but we need to understand the risk very well for us to provide you terms. And then we need to understand the details of professions, their background, and then a fee income. Reason why we ask for fee income is we want to see how big the size of the firm, and how active is the insured in carrying out their service. Then limit of indemnity required, and also claims experience. And as for single project PI, we also look at proposal form and a letter of award. From letter of award, we will see the duration of project, contract value, and scope of works. Basically, these are informations that not only GE, but also other insurers will look at in assessing the risk. This is, I think, similar to the previous slides. Maybe selling tools for you, to highlight to your client on the reason for buying liability cover. Okay, it is basically to indemnify the insured for any claim or legal costs that they are liable. So it's a protection for them and their business. So not a strain to the insured's financial out of pocket. And it provides insured with a peace of mind, and it protect them from any adverse publicity. So this the maybe a result for failure to ensure their activities, their professions, or their business. Number one, loss of reputations, and loss of personal assets, or maybe the worst, bankruptcy and loss of their business. Okay. Here's the interesting part, claims example. Okay, number one, collapse of roof on row of shop houses. Okay. Basically, a row of shop houses with a fancy roof was designed by an architect. The engineer then did structural design, and the shop houses were built. In a heavy rain, the roof collapsed. Okay. Architect was named in the suit. Most likely, it will go back against the engineer who is responsible for the structural integrity. And the architect was merely responsible for the loop. Singapore claims and loss was about hundreds of thousands. Okay. Counterclaims that made by third parties alleging breach of professional duties to avoid payment of outstanding fees. And looks like these claims do not have merit. And the third example, collapse of retaining wall in a housing project due to design failure, with a claim amount amounting to $500,000, which was paid. And here's other claims example, from accountant. For example, is incorrect tax advice, and get fines by tax officer, and real estate agents, surveyor, and also solicitors. There are more claims example actually, where we could actually highlight to the clients or potential clients. Have any questions?
Lina, do we cover a single project
No questions.
PI? Let's say for those project at overseas.
I cannot see from here.
Overseas project. Can you hear me?
PI
Hello?
is mainly for individual professionals only.
Uh-huh. No, I'm saying that they said because especially engineer, they may
Okay.
have some project.
Um,
Their client
we
may be
basically
local.
provide PI cover for both individual and firm based.
Yeah, but the project risk is on overseas.
PI.
Okay. Sorry. Okay. Sorry. PI is actually written on firm basis.
Uh-huh.
We provide cover for firm.
Yeah. I'm saying that the firm, you see, for example, they have a local client, then the client they go to the overseas to build. Doing some project construction there. So this
More questions?
PI, can they, if they say the client, their insured want to cover the overseas project, can it be extended or only local project?
No questions? No questions.
Sorry, because the line is breaking up. Do you mind to repeat your, Mala can pick it up from here?
Okay. Ariamala, the question is overseas projects covered or not? Okay. The question is asked by Mr. Teo.
Okay. Overseas, usually for project, I believe you're referring to annual cover or project specific. Okay, let me explain both now. For annual policies, okay, if your overseas work, whatever work you're doing for projects over incidental to your main scope, which is normally provided for in Malaysia, then it's fine. Okay, we will cover. But if it is a project specific policy which covers a particular project overseas, I'm afraid we would not want to write the business because sometimes overseas, they have to buy a policy locally, just like Malaysia, to comply with the local laws. Like Malaysia also, if you have a property or is the project, you're doing a project here, you must buy insurance locally, not buy in any other country, right? So similarly, like Indonesia, Vietnam, there are a few countries which have locally admitted laws, say. So you must buy from those countries, cannot buy from Malaysia. Okay, why we don't want projects overseas? Because can you imagine the cost that we will incur if there's a claim to actually liaise with somebody, some adjuster there to go down and assess the claim. If there's a summons file, to get lawyers to actually defend the claim. And also another reason is the legal landscapes may be very different in those countries. So because of that, we prefer not to write overseas for projects.
Okay, thank you.
Is there any further questions from the ground? Otherwise, then we should end the session. And thank you very much, everybody for joining this wonderful sessions. I believe that you have a very wonderful, takeaway from, the information, that's shared by the Mala and Amina, pertaining to this, liability insurance. And stay tuned, yeah, because we have launched the polling questions. As usual, yeah, please answer all the polling questions, which have 9 questions in total. Then you may get it submitted, and then you may leave the meeting room. Thank you very much, everybody.
Thank you. Okay.